So I actually have a question
Hmm.
in reference to that. So we have various presidencies throughout our history that has taken more power or a more of a delegate role in government. I think the last time we actually saw a president that used full presidential authority was like FDR, right? So
And he
when we
made
look at,
some cool things.
yeah, he did some controversial things too, though.
Yes, he did.
Right. so, so I think that when our country gets to a certain point where we're going to zig or zag, a leader presents themselves to be that pivotal role
Hmm.
as the president. So, I mean, would we agree that we are at one of those moments in our history?
No.
Yeah, not even close.
Okay, so what would be your definition of a corrupt, inept system that no longer uses their powers as intended, like Congress, usurping their authority to the regulatory body with regulations and statutes, right? And you have a Congress, the 118th, and arguably this one for that matter, have been like completely ineffective.
So the answer to an ineffective Congress is not a president to do all of Congress's actions, nor a president to ignore the Constitution, nor a president to ignore the courts. That's not the answer to an ineffective Congress. The answer to an ineffective Congress is going to be a more active voter base. Chances are, but
More fractured party
we have
voting.
democratic actions that we can take to fight against an inactive Congress. The answer to that is not to elect a dictator who can swing the federal government around as a sword.
But I mean, arguably, right, the powers alluded to, whether it be Article 2 and or legislation already passed,
Mm-hmm.
arguably he's already been given that power, and we just haven't had a president that uses that power, right?
I mean, I think there's a
So
reason that you said usurp, because I mean, he's not only using power that hasn't been given to him, but he's also taking power away that hasn't been given to him. Like when he's trying to get rid of three-letter agencies unilaterally with an executive order, even in if you want to say, well, he's not getting rid of it, he's dismantling it, or he's just removing its ability to function, that's still a meaningful encroachment on congressional power. Or, as was ruled today, his tariffs, that's like still a meaningful encroachment on congressional power. He's not just inventing new power that the president has that hasn't been used. He's taking power away from the other agencies
other agencies. So
or
let's
other
just
branches.
so when you look at Article 2 powers,
Mm-hmm.
is the executive branch all said agencies, or is that power invested in one person, the president?
Unitary executive theory, the idea that the president controls the entire executive branch, is just not coherent with the way that our government works. There is a lot of power that is centralized in the president, and he is the head of the executive branch. All of these agencies are within the executive branch, but that doesn't mean that the president has unilateral power over the entire executive branch. That's just not what it means.
Okay, so with what you just said, right?
Mm-hmm.
Where in the Constitution does these agencies gain their power?
They're made by an
Do
act of
we have
Congress.
27 branches of government, or do we have 3?
They're made by an act of Congress.
Right, but then you would not have 3 equal branches if Congress has the ability to make agencies outside of the authority of the other 2.
They're not outside of the authority. It's just not within the complete authority. So the president still has authority over the three-letter agencies. He just doesn't have complete authority to get rid of them because they were made through an act of Congress, and the president cannot get rid of an act of Congress through an executive order.
So I assume that you're discussing the Department of Education, correct?
There's a couple of them, yeah.
Okay. So Department of Education was instituted by an executive order, correct?
Um, I'd have to see. That's not my impression, but maybe.
Yeah, so an executive order instituted the Department of Education and then Congress thereafter funded the Department of Education. Hence the reason why they have the power of the purse.
Was not started by executive order, I believe.
Sure about that?
Correct me if I'm wrong. I thought it was like
no,
partially
yeah,
like it was
President Jimmy Carter signed the Department of Education
Subsequent.
Organization Act into law.
I'm pretty sure it was a campaign promise by Carter.
Right, it was an executive order that turned into the act,
Oh.
which, yes, absolutely.
yeah, it's like a petitioned Congress kind of thing,
Hmm.
right?
Same thing as what Trump is doing with his executive orders, and then he's
But I
looking
wouldn't
to
say
Congress to
that that's
codify
kinda like
those executive orders. Same thing.
that.
Well,
I
no,
wouldn't say it's like
you could
that,
say
though.
that an executive order petitions Congress to create something, but an executive order trying to get rid of it without Congress is not the same.
So I think that when you look at the written word of the Constitution, right, you do realize that all of these agencies under the executive branch, they all have authority at the luxury thereof, correct?
No.
Where in the Constitution does it not
So
state that?
when the president nominates his principal officers, they need confirmation from the Senate, right?
Mm-hmm.
So he doesn't have the unilateral authority to choose the heads of his executive branch or the executive office, right? Like he doesn't have the unilateral authority to put these cabinet officials in place, right? That's not a unilateral authority that the president has.
Yeah, they need to be confirmed unless they're in recess, and then therefore they can make recess appointments. But he does.
If the president had full control over the executive branch, why would he need congressional approval for appointments?
Well, I would argue that you are correct. I will concede to that. But he doesn't need congressional approval to fire them.
Right, but he needs a congressional approval to replace them,
Correct.
right? But he does also
Yeah.
need congressional approval to get rid of an agency.
It depends on the
No, it doesn't.
the structure of the agency. For example, like USAID, right? Like that was always under the State Department, right?
Mhm.
But it worked outside of the direct oversight of the State Department officially. And so Marco Rubio always had, or well, in this particular case, Marco Rubio, but Secretary of State always had the overriding ability to say yes or no to anything that USAID did, right? And so therefore, because it was an agency basically within an agency, that is why they had the authority to absorb USAID back into the State Department.
Yes,
Because
absorb it
basically-
back into the State
yeah.
Department, not unilaterally get rid of it.
Correct. Right.
Right.
Like there
Right.
are parts of USAID I disagree with by such a high degree, but just full shot stopping it, that's crazy.
Well,
That's,
we're just
like,
talking about like legal authority allotted to the president, and
Yeah.
let's try and keep. I want to try and keep one v one with this guy.
Mhm.
So
So, go ahead.
that we can agree that the president doesn't necessarily have full control over the executive branch, because like the appointment of principal officers wouldn't make sense then. Our past precedent saying you can't undo acts of Congress even if it relates to the executive branch, that wouldn't make sense. And that's what the application of the three-letter agencies is these are made by acts of Congress, and Donald Trump can't just get rid of that. In the same way that he can't just change the content of any law.
Sure, I would concede that as well. But let's take, for example, Department of Education, right? We look at the mission of said department and the effectiveness of said department. And so a person could argue that their ineffectiveness in the mission statement for that department could be just cause for the executive to take action, because it is up to him
How?
and on it's his responsibility to effectuate the laws that Congress write. And so if we have a department that is being funded but is being ineffective with those funds, then it's the president's
You're
responsibility
telling me
to
that
address that.
there's a good faith argument that could be made that Donald Trump could ignore the funding from Congress because he doesn't think that the funding from Congress is effective?
Essentially, yes, absolutely.
That-
Because he's the executor.
That's just not true.
Okay, so is it not the president's responsibility to uh, execute or
It
to
is.
ensure that it's being executed per the law?
Yes, and the law is demanding that this
Okay.
funding gets spent that way. It's not the president's
Correct.
job to say, I think enforcing the law is ignoring this law.
So here again, I do believe that Congress is going to have to pass some type of legislation to redirect the funds and the distribution of said funds. But could we agree to say that the Department of Education was just an intermediate department between the Treasury and the state and local institutions for education?
I don't know if that would change its legal classification, but if you want to like colloquially refer to it as that, then yeah, maybe.
Right. So
That doesn't
basically,
change its
we're
legal
just
status.
right, but we can just basically look at it as we're going to get rid of the middleman in the process and give funds directly to. Like it's still allocating funds per the congressional funding requirements. It's just they're going to have to make an amendment to said funding.
Yeah, sure. I just don't think that the president has unilateral authority to do that. And I think that the unitary executive theory that you were positing at the beginning, that Donald Trump just can do whatever he wants whatever he wants within the executive agencies, is kind of the whole problem that I'm having with Trump and Trump supporters, is that it's just all about centralizing power to the president.
Sure, and this argument is not new. I mean, this is going back all the way to Grant. Grant wanted to make these, very broad, sweeping actions, and was very frustrated because Congress stood in his way and effectually, prevented him from doing a lot of things in his presidency that he wanted to. His documents clearly, state this to be true, and so it began the argument that, is the executive, i.e., president, just a dignitary, the highest thereof, and its real power is held within the Congress, or is it more than that? And I think that this is where we find ourselves in the conversation.
Well, we have a lot of Supreme Court precedents to back up the idea that the president is just there to enforce the law and not to unilaterally act beyond congressional authority.
But I think that, like, when we look at the Patriot Act, and now that we have this executive immunity, right? It does change that perspective quite a bit. Would you not agree?
No, I wouldn't agree, because anything that the Patriot Act allots to the executive branch is going to be through congressional appropriation, so that's not going to be relevant to that understanding. And then the presidential immunity, I'm assuming that you're referring to Trump v. U.S., doesn't actually grant any specific power to the president other than his actions not being criminally reviewable.
Correct. And that, along with emergency powers, I think that the argument of what you're trying to make falls on facts of the matter. So if this
What
is
do you
just
mean?
a dignitary and an enforcer of said decisions that the other two branches have made in conjunction with each other, wrote the law, interpret of the law, and therefore he's just an administrative individual, right? Then why would they then in turn give him emergency powers? Makes no sense.
For foreign policy, he's not just there to enforce the law. I think the founders wrote about this pretty extensively, that we just need a unitary figure that can act swiftly when it comes to national emergency issues. But that doesn't mean that he can just ignore Congress when at peacetime. That doesn't mean that he can just go against the courts and go against the legislative willy-nilly. It just means that we grant him some level of deference when it comes to foreign policy matters or diplomacy matters.
Well, I agree with you 100%. So if we apply the situational grants of emergency powers to act swiftly, right? If the president uses those said powers to say, hey, these people are T groups, right? And this is an incursion, and this is the proclamation that I'm making, and its true intent of giving him those said powers, or I should say the president, because it could be a he or a she. I really don't care. But if the intent is swift action, then would you then state that the judicial is interfering with that swift action which is intended?
No, because swift action doesn't mean swift action at the cost of anything, or swift action regardless of the consequences. When we are encouraging swift action within the executive, that doesn't mean that we basically trample on these people's due process rights in order to get them out of the country quicker. That's not in the nature of our Constitution. And I think if you ask any founder, hey, before we punish somebody for being a part of a terrorist group, should we give them the ability to challenge the fact that they're a terrorist? They would all say yes.
Sure. So when you look at Section 412 of the Patriot Act, it lays these things out very specifically, and what that process looks like to a T group individual. Specifically says T suspected T group, right? Individual. And so the first step here is habeas, clearly laid out in a 7-step process, right? And so when we look at this and the declaration and putting all said things together, the Supreme Court's already ruled that the Patriot Act is constitutional, right?
Wait, are you talking about the Patriot Act or the Alien Enemies Act?
The Patriot Act specifically, Section 412.
If you're talking about using a proclamation of a predatory incursion to justify deporting terrorist groups, that's not the Patriot Act, that's the Alien Enemies Act.
Sure, and my argument is that he didn't even really need to use the Alien Enemies Act. The Patriot Act clearly covers these said things within Section 412.
But the problem is that he was deporting so-called or alleged alien enemies without giving the alien enemies the ability to file for any amount of relief or have any notice of their ability to file for relief.
So my view of that is simply this. Let's say you have an encounter with the police, right? Like, you have the Fifth Amendment right to remain silent. Now, you can invoke your Fifth Amendment right and say absolutely nothing, and you would be fine because you're going to stand on that right. Or you could choose to talk to the police, and you could waive your Fifth Amendment right. Okay, but by no means does the cop have any prudence in the interaction to advise you of your Fifth Amendment rights. As an individual, you're required to know your rights, and it's your personal.
Cops are required to Mirandize you.
Well, Mirandize is different, but when they're doing an investigation, okay, you have the right to remain silent and not self-incriminate, correct?
Yeah, and they tell you of that when you get arrested.
Okay, no. I'm talking about the investigatory interaction. Like, you have no requirements to assist in their investigation. Like, if they're going to investigate, they can investigate with you saying absolutely nothing. And my point, and the reason why I bring this up, is because a person being detained,
they would get the if that investigation comes up with something, the person who's being investigated would always get the opportunity to challenge the results of that investigation. Right.
And so hence the reason why I go back to habeas. And if you, I, or in this case, Mr. Garcia specifically finds themselves in detainment, they should know said rights and stand on those said rights and demand habeas
No,
hearing.
that's contrary to what the Supreme Court even ruled, that these people need notice to habeas.
Well, I think the notice goes back to the notice of status change, specifically in that case. So when Marco Rubio removed his protected status of non-deportation due to whatever reason, I'm not going to get into that because it doesn't apply. But I would say that that lack of notification of status changes is the notice of due process
So
violation that they're referring
you're,
to.
you're mixing up different cases. So Comar Brego Garcia was not deported under the Alien Enemies Act. The people who were deported under the Alien Enemies Act was a class named JGG. These people were not given the ability to challenge their designation as an alien enemy. They were being detained by ICE before the proclamation of the Alien Enemies Act had even become public, and they were not given the ability to file for any challenge to their designation as an alien enemy. And the problem is that they ended up catching word because the plane broke down that was supposed to ship them off to El Salvador. They ended up, because the plane broke down, they ended up catching word that they were being deported under the Alien Enemies Act and were able to get a class action lawsuit out. JGG versus Trump, the Supreme Court decision, ruled that these people have the ability to challenge their designation through a habeas petition, and that they have they're entitled to notice of that ability. That's what they ruled in JGG.
So I understand, and this is the Boasberg case, correct?
Mm-hmm.
Right. So then we look at the case going back down to Boasberg,
Mm-hmm.
and they want to do a hearing of discovery, right? To figure out what the government is going to do, the status updates as to what the government is going to do as far as effectuate, right?
No. That's
Or
Garcia.
facilitate.
That's Garcia versus Noam. That's not JGG versus Trump.
Okay, JGG is the one that tried to make. Is that the one that tried to make the protected class for all TDA members? Is that the one?
The protected class for all TDA members. That's the one that prevented the Trump administration from deporting the alleged TDA members before the case had been litigated. But the case ended up getting dismissed because the Supreme Court ruled that the correct jurisdiction to file that claim was habeas, and then it got re-brought up in AARP versus Trump. I think.
Okay, yes, and that is the one that went down on Easter weekend, correct?
I believe so.
That was the one that Thomas and Alito gave their scathing review on how the Supreme Court, for the first time, overstepped their jurisdictional boundaries.
Yeah, they were the only two to dissent. Yeah, sure.
Correct.
Mm-hmm.
So, I mean, if we're going to talk about that, it's a very, very important case because we're I think it's Mulberry versus Madison. Is that correct?
Madison. That's the judicial review. Yeah.
Correct. And so it's this idea that judicial review can rule on a case that hasn't even officially been ruled on. I mean, 33 minutes for the Texas judge to go ahead and do a formal writing of findings of not providing evidence.
Do you know why?
Yeah, their claim was that there was going to be irreparable harm, but in that particular case, the government already said that they weren't going to be deporting these individuals in this time frame that they were asking.
Why would we trust the government's word on that when they said that they wouldn't do the same thing to the JGG class, and they were literally putting people on planes and flying them out during the trial to hear the TRO? Why would you trust the government's word on that?
Well, in the previous case, the government was instructed not to have DHS deport, and they followed that rule and had the United States military deport. So technically, they did abide by the order.
So why would you trust that the government is going to adhere to the order to not deport the plaintiffs if they've already shown that they're willing to find loopholes or to do it during the case's merits being heard? Why would you trust the government wouldn't deport the class?
Well, I think it's a classic situation of the canary in the coal mine acting like it's unalive, but it's not. Okay. And so here again, we have outrage on a scenario that is being broadcast as Frank Sinatra, but it's really Elvis, right? Like they misrepresented their case. And that misrepresentation went up to the appellate's court, and the appellate's court said they have no jurisdiction because there was no case judgment rendered. And so then
In what,
there were no.
AARP?
Yes, and then I believe it was 7.5 hours later, they had petitioned the Supreme Court on no written finding, and the Supreme Court weighed in based on Mulberry versus Madison on their judiciary review on a case that hadn't even been decided in the first court that heard it. So, I mean, if you read the appellate's
Wait,
court,
yeah, because that's yeah, their preliminary injunction got rejected by the district court, and then they were seeking an emergency order on the grounds that the government wouldn't comply with the injunction. Why is that not reasonable?
Well, you can't have an appeal on something that was never technically ruled on because the ruling hadn't come out yet.
I don't know
And
if that's
so,
I don't know if seeking an emergency order is necessarily an appeal.
so I think that the burden of proof lies within the petitioning party to say that irreparable harm is going to be done, and the lower court that originally heard the argument decided that they did not rise to the level of irreparable harm.
Yeah, and then they appealed,
So
and then they ended up seeking an emergency order.
right,
And also,
and
in AARP, wasn't it found that they actually had people on the planes already still?
no, that's incorrect.
No?
And even when it went to the Supreme Court almost 8 hours later, there was no proceedings of any of these individuals. Actually, it was one individual. It was actually having the process of being moved, removed, anything of the sort. So the Supreme Court did something that it's never done. It's walked outside of its judiciary jurisdiction and came in with a ruling. Thomas and Alito wrote their dissent, and then it went back down to the appellate's court, and the appellate's court wrote their scathing review of what the Supreme Court did. And I think, correct me if you disagree, but I think what we're watching here is the judiciary system being exposed
No.
for not
So
following the laws.
So SCOTUS already said in the opinion that there was evidence in the record that the government was taking steps to deport the class.
Well, sure, they can take steps. They can have these individuals fill out forms.
Is taking
but
steps to deport the class not a step towards irrevocable harm towards the class?
no, because the government in this particular case stated that they were not going to deport this individual. So where's the irrevocable harm?
This individual. What? I might. Okay. When you say might not won't deport this individual, who are you talking about?
The JJG and the AARP, right? That's the progression.
Those were classes. They committed to not deporting the class.
Right. And so there's even an argument to be made here that the second that a judge, Boasberg, in this particular case, in another case, said the perceivable protected class, right? There's a perceived protected class. Anyone designated to be in this TDA group, right, is now like a class action group, right? They actually, the judge removed their individual habeas claim rights by doing that, by including them into this perceived group. Now an individual can no longer represent themselves. It has to be within this group, right? Similar to class action, right? It's not an individual, it's a group from this point forward. And I don't think that the judge has the right to turn that into a protected class without consent. No different than a class action, right? You have to have signatures. And so here again, what I believe is happening here, strategically, I might add, is the executive, which is in charge of executing the laws, is is wanting the judicial branch to act decisively, right? And so the Supreme Court, in error, in my opinion, is letting all these individual cases happen. These things need to be bundled up if there is a protected class, as they so say, right? Then these things need to be bundled up. These individuals need to first sign authorization that they even want to be a part of this group to give their individual rights away to habeas. And then, therefore, that one big case is going to be judged on and have a final ruling. This, springboard to the Supreme Court every 15 minutes is a shit show.
Well, I mean, I'm pretty sure they took it up to the Supreme Court the first time for the TRO. I'm pretty sure, and then second, so I still don't understand how this. I feel like this kind of walks off the point. I mean, if we have reason to believe that they were not providing the JGG class action with their due process rights, and they were trying to get them on the plane as quickly as possible to remove them before they could file for any sort of relief, and then 2 planes already took off during the court hearing, why would you say that that's not, and they're already taking steps to deport this new class after JGG was given down? I don't understand how you couldn't say that there's not irrevocable harm, especially when they're arguing as soon as you're outside of the country, even if you're on a U.S. plane, you're outside of our jurisdiction and we have nothing to do there. How is that not irrevocable harm? And how is a temporary injunction to prevent those people from being deported while the case litigates, how is that bad?
Well, I think that the responsibility falls on the shoulder of the Supreme Court, not actually making decisions. Okay,
they did make a decision though in JGG.
But did they make a decision?
Yes.
Okay, so the issue here is much broader than the individual like shotgun case perspective that we've been seeing. Like, oh, it's this case in Washington D.C. We have the JGG, we have the ARP, we have all of these different cases simultaneously running concurrent, basically dealing with the same issue, right? So the Supreme Court should have, in my opinion, taken all of these cases and look at it as, is the executive branch
AARP only
usurping?
AARP only started because JGG ruled that habeas was the correct venue. So AARP wouldn't have happened without JGG. So why would they rule on JGG and AARP if AARP only happened because of JGG? And I'm pretty sure that those are the only 2 lawsuits surrounding the like large-scale lawsuits that have been ruled on by the Supreme Court to decide the Alien Enemies Act.
Right. And so there again, we have the overwhelming question still looming, hence the reason why we're having this debate today, because the Supreme Court should have
What question
decided.
is looming?
The question that is looming is whether or not the executive, under emergency orders, under the Article 2 powers and the Immigration and Naturalization Act of 1952, have the authority under the Patriot Act, designated T groups, the authority to remove people in accordance with Section 412 of said act.
They already ruled on that the Alien Enemies Act is constitutional, that their usage of it is theoretically constitutional, but you have to provide the people their due process rights and give them the correct notice and the ability to file for a habeas claim. They ruled that twice. How is that not clear?
Well, did they give a time frame?
They did not give a strict time frame, but they said under a day it surely doesn't meet the bar.
Right. So ambiguity was left by the Supreme Court. Would you agree?
Is that the big criticism, though, that they didn't specifically outline what notice means, so it was okay for them to try and deport these people without giving them the ability to challenge?
So specifically in the Patriot Act, in this Section 412,
why are we bringing up the Patriot Act when this was done on the grounds of the Alien Enemies Act? The Patriot Act is irrelevant here.
But was it?
Yes.
I argue that the proclamation and the emergency along with the Patriot Act, is all the president needed. I don't even think the invocation or the inviction
The
of the
invocation, but
alien
they didn't even cite the
invocation.
Patriot Act.
And that's and in my legal opinion, that's a failure on their part.
Okay, but
Like
that's
failure.
fine. But trying to litigate their actions on the grounds that you think they could have done something a different legal way is not saying that they're doing it a legal way, or saying that like what they are doing is complying with somebody's rights.
So what it says in Section 412 is that a T group individual, right, that
It doesn't
fits,
matter. This isn't the law that they were citing to deport these people.
but it's a law that outlines the guidelines. It
But it's not
specifically
going to
says
overwrite what the Supreme Court already ruled, that these people have the right to file for habeas, which Donald Trump was
they
not
do.
providing
Yes.
them.
Right. So then we have two questions that we need to uh, discuss, right? And that is, in the Patriot Act, it says that the government is allowed to hold an individual without any due process for a total of 7 days.
Mm-hmm.
Okay. After that 7 days, they either need to A, release them, and or give them written notice of deportation. Okay.
Mm-hmm.
Or additional detainment, right? And so it is up to the complainant to invoke
No.
this habeas.
SCOTUS already ruled that that's not the, well, first of all, that's not the piece of legislation that they're doing it under, so the Patriot Act doesn't apply here, first of all. Second of all, SCOTUS already ruled that simply habeas existing isn't, it doesn't pass the bar of giving them the ability to file for habeas.
So, for example, let's say you had a conversation with the police officers that were investigating you, and they had a conversation with you, and you self-incriminated yourself, and you didn't invoke the Fifth Amendment. They arrested you based on your own admission, right?
Mm-hmm.
And then they told you they read you your Miranda rights. So the argument is this: could that evidence of you self-incriminating yourself prior to the arrest during the investigation be used in court as evidence?
That's an irrelevant question.
It's not, because the argument is, who is the burden placed on to
We already
invoke habeas?
have a ruling on that.
And what does it say?
It says that they have to be given the opportunity and notice. They have to be, and notice doesn't just mean notice that habeas exists. It's some amount of notice of deportability, which was not provided to them in JGG and was not provided to them in AARP.
And is that the argument, that it was written in a language that they couldn't understand, and they were asked to be signing documents that they had no purview of?
That's part of it.
Okay. Well, I mean, we can agree on that, because I do think that, somebody needs to understand what they're signing. I'm one of those people that, like, makes the whole room wait while I read the fine print.
Mm-hmm.
I get it, right? So why can't we just put these matters to bed and have the Supreme Court come in and say, hey, we're going to give the complainant 21 days to file for habeas, unless they are deemed to be a T group member. Therein,
I would love
7
that.
days.
I would love that. I would love a more clear SCOTUS decision. I don't think that at all lets Trump off the hook for what he's doing.
But doesn't that really lay the landing zone or the runway for the executive to actually get the deference that it deserves in this process?
Does what lay that ground?
So if the Supreme Court brought all these groups, these cases together, because they're addressing the same issue, core issue, right? And this is something they do all the time.
It depends on what cases you're bringing up, because AARP and JGG couldn't have been lumped together because AARP was directly, it came off of JGG, and those are the only two cases that are referring to the problem that we're talking about. Mm-hmm. So there's no case that we can lump together here that I'm aware of.
So right now, this case is with the Fifth Circuit of Appeals in the state of Texas, and they've just written their scathing review of what the Supreme Court has done. Mm-hmm. This yo-yo up to the Supreme Court is really kind of making a mockery of the judicial system. I don't think that the Supreme Court has been decisive enough.
I agree, but I'm saying that that doesn't let Trump off the hook for fundamentally removing these people's ability to challenge their designation as an alien enemy. Something that every
Mhm.
other alien enemy has been able to do, even the ones if like put in front of the alien enemy hearing board and for the Japanese internment camps. Even those people were given
Sure.
more ability to challenge their designation than the people under JGG.
Yeah, because I believe wasn't that with like the senators in congressional hearings, correct?
It was, I think, some level of congressional involvement, but the attorney general was the one who headed the alien enemy hearing board, and you would basically be put before it. And if it was decided that you were an alien enemy, 14 years or older, then you were gone, and that constituted your
Hmm.
due process rights. We didn't even provide
Hmm.
them that. We didn't even give them the ability to challenge at
Hmm.
all their designation.
Hmm. So when we historically look at like the interaction between like England soldiers on American soil, whether it be during, before, or just after the war, right? Um, this is really where this law found its home within the laws of this country, and so with it being intended to be swift and decisive, right? Um, would you say that we needed a Supreme Court ruling, or would we say we need clarification on the historical perspective? Because when we look at the Supreme Court decisions, whether it be Bruin's on the Second Amendment, it's a very intentionalized, organic perspective of what the intentions were, right? And so, if we look at that in the same perspective as the Aliens and Enemies Act, it was with the intent, the organic perception of swift action, correct?
Um, kind of.
Right. So we now have a situation where the Supreme Court is not really being consistent with the organic originalist perspective when it comes to the written word of
But
whether it
that's
be the
not
Constitution and or of law.
saying that the people should have the ability to challenge their designation is not saying that it's not a more summary way to deport people. Like saying that before you deport somebody, allow them to say that they're not who you're saying they are. That's not getting in the way of swift deportations.
So I think that the idea of habeas is meant to be swift and simplistic in nature. And I'm not saying this is you, and I really appreciate our conversation
Mm-hmm.
because I think that it's good. But there are people out there that say due process, and think that somehow these individuals deserve like a trial of some sort,
No.
and that's just not based in reality, right?
They just deserve some level of ability to challenge their designation as an alien enemy.
Can you describe what you think that should look like?
What that should look like or what that does look like?
In your opinion, just uh, what that should be.
I think you should be able to be put before somebody who has reasonable nonpartisanship, to be able to challenge the facts of your designation as an alien enemy. So if somebody says, "Hey, you are a Japanese immigrant and you're over the age of 14, you should be given a reasonable ability to or reasonable notice that you're deportable," which I think generally is considered to be like I think it's 10 days, and the ability to like get your documents and shit and bring it before the board and say, hey, here's my birth certificate, here's the reason why I'm not removable under this order, and either you are removable under the order and you get removed, or you are not removable under the order and you're not. Now, I will say that if you're asking like my personal opinion, I probably have a problem with the emergency declaration of a predatory incursion as well. Like I don't think that this is an appropriate usage of the Alien Enemies Act, but I don't know. I think that that's still like up in the courts, and I don't know if there's like a super binding precedent to determine that. So I'm actually pretty sure that there's not binding precedent to determine the constitutionality of the president's invocation of predatory incursion under the AEA. So I'm not going to make like a legal claim on that.
Sure.
But yeah.
So when we proclaimed the invocation of inviction or
Invocation.
invocation,
Yeah.
yeah, of the Aliens and Enemies Act the last time,
Hmm.
the courts weighed in and said, "Hey, these individuals deserve this a process," and that process was determined to be a congressional proceeding
Yeah. Yeah.
where people were given the opportunity to, like you said, provide documents, a birth certificate, whatever, and then a decision would be made, and you were either gonna be put in the camps or you were gonna be released, right?
Hmm.
And so even after that said process took place, there were reparations that were paid out because of improprieties of that said process, right?
Hmm.
So historically, it's imperative that the Supreme Court actually do its job and outline that said process. If it's not clarified, whether it be in the Immigration and Naturalization Act
Uh huh.
and or the Patriot Act, right?
I mean, yeah, you're if the only point that you're trying to get out of me is that the Supreme Court should have been much more much more clear about the order, then I'm probably going to agree with you. I'm not
Yeah.
necessarily a giant fan of this court. A lot of the reason why is because of the immunity ruling, but uh, yeah, I mean, I could agree with you there. I just don't think that that washes the hands of Trump, especially when I think you just made a really good point, actually, where if it's true that we were paying reparations to the people that we used the Alien Enemies Act under last time, and we gave them more due process rights than we're giving to the JGG people now, then that should have been even more reason for the Trump administration to know that this was not a legal or appropriate use of it.
Sure, and I'm the biggest supporter, but then again, I'm also the biggest, criticizer of this particular policy. They made it way more difficult than necessary, in my opinion. They had laws already on the books to provide the process for them to do all said things. I think that myself. I voted for Barack Obama first term because he said he was going to do away with the Patriot Act. He was going to do away with Guantanamo Bay, and that he was going to restore our rights. Unfortunately, I think that a lot of people are arguing the wrong points in this argument, and it's not that the president is outside of the law per se, that he's only using the tools that the Congress has given him, and we haven't seen that in a president in a very long time, arguably a couple of generations. So it's this, oh my gosh, what's happening, when it's really just an FDR-esque presidency.
I totally disagree, but I gotta get off. It's like I'm in EST. I don't know what time zone you're in. It is 6:19. I've been up since 9 yesterday,
Yeah.
so I've been up for a solid
No.
24 hours. But
Well, yeah, you need to get your ass to sleep. But I dropped you a follow. I appreciate you entertaining the conversation. I think it was good.
mhm.
And if you get a chance, maybe just check out that Section 412 in the Patriot Act. It lays it out very clearly and very decisively on what the pathway is to proceed with these types of issues.
Yeah, sure. I'll take a look at it. I
All
appreciate
right,
you dropping the follow. Hopefully, we can have a conversation again in the future.
absolutely. Get some sleep, man. Don't forget to drink some water.
I'll try my best.
All right, see ya.
See ya.